Welcome, everybody. I am recording. I want to thank you all today for joining us on this webinar. I'm Melissa Rosenberg. I'm the Executive Director of the Autism Society of Maryland, and joined today by our wonderful partners at Pathfinders for Autism. We have Neil Lichter, who's here today. Neil, did you want to say a few things?
No, great registration, great turnout today, and I'm looking
Great.
forward to hearing what Jim has to say. He's a great speaker, and I'm always happy to partner with Autism Society of Maryland. We've been working together a long time.
We sure have, and we both have terrific resources. We'll stick our the website into the chat, and so you guys please feel free to reach out and check those out. So today we are thrilled to be partnering, as I said, with Pathfinders on this what we call a brown bag webinar, Alternatives to Guardianship. And before we begin, I am going to introduce Magda Castro-Lewis, who will give us some instruction. This session will be recorded in Spanish, but we will have simultaneous Spanish interpretation. And Jaden, if you can turn off your camera, that would be great. And Magda, I'm going to turn it over to you to give us some instruction on, for those who need, how to access the Spanish language room today.
Ok, Melissa, thank you so much. Gracias, Melissa. Buenas tardes a todos. Yo soy Magdalena Castro Lúez, cofundadora de ALMA, Servicios de Traducción e Interpretación. Bienvenidos al webinar titulado Alternativas a la tutela. Las personas que desean escuchar la presentación en español lo pueden hacer yendo a la parte de abajo de la pantalla, hacer clic en el globo y escoger la opción español. O también puede ir a los 3 puntos y lo mismo, escoger la opción español. También quiero recordarles a los participantes que mantengan sus micrófonos en silencio y las cámaras apagadas para evitar interferencias en la presentación y la grabación. Si tienen preguntas, pueden hacerlas en el chat del Zoom y al final serán contestadas. Ahora los dejo con Alicia Ardila Fortier, quien va a hacer la interpretación simultánea del seminario. Ella también es la cofundadora de ALMA, Servicios de Traducción e Interpretación. Thank you so much. Gracias. Okay, Melissa.
Gracias, Magda. Thank you so much. And now I'm delighted to introduce our presenter today. James Silver is a supervising attorney at Maryland Legal Aid. He specializes in adult guardianship. Jim is a 2007 cum laude graduate of American University, the Washington College of Law, and a 1997 graduate of New York University. He spent 16 years practicing special education and disability law, as well as handling complex guardianship litigation and creating alternatives to guardianship. He also serves as co-editor on the updated handbook, Guardianship and Its Alternatives, soon to be published by the University of Maryland Francis King Carey School of Law and the Maryland State Bar Association. Before beginning his legal career, Jim served in the Peace Corps and had a 5-year career as a journalist in Northern Virginia. Outside of work, he enjoys finding new recipes and cooking for his wife and 2 daughters. So welcome, Jim. Thank you so much for being here. And we're looking forward to hearing from you. So I'll turn it over to you at this time. Thanks you
very much. So yeah, as Melissa said, my name is Jim Silver. I am the supervising attorney for the Adult Guardianship program here at Maryland Legal Aid. In this program, we provide court-appointed counsel to the alleged disabled person in guardianship proceedings in multiple courts around Maryland, around the state. And we can talk a little bit more about what that means, alleged disabled person, and what court-appointed counsel means. But that's what our program is right now. Previously, as said, I worked with the law office of Caligari and provided, among other things, guardianship representation for petitioners and for the alleged disabled person there, and also along with working in other areas related to disability benefits and special education law, and also dealing with family law. So I will, let's see if I can be added as the presenter, or host. I can start my
Yes, I'm going to do that right now. And I'm going to ask Trina if you can turn off your camera. That would be great.
Okay,
Thanks, Trina.
okay. Let me
Yeah, and if everybody remains on mute, Kathy, you as well. Thank you. And I'm going to find you here, Jim. And I'm going to make you the host.
Okay.
Thank you so much.
Okay. All right. I'm going to, let's see here.
Kathy, are you able to turn off your camera? I know you're looking. It's okay.
From beginning.
Either that or we're going to ask you questions about alternatives to guardianship. Just teasing.
Okay. All right. So does everybody see the main slide here?
Yes.
Okay, great. So, as it said, this is about alternatives to guardianship, but also just a brief overview of the guardianship process. This is me down here, and so we will get started here. So we're going to talk about one of the sort of underlying principles here is the legal and ethical requirements for informed consent for adults. Minors, generally speaking, and I'll talk about this a little bit in terms of informed consent, but in terms of decision making and the surrogate decision making or have someone else making decisions for you, minors are presumed to have their parents as their natural guardians. And without going into the detailed legal discussion about that, that's sort of the backbone. So what this really comes into play is when we're talking about adults. So that's why we're going to generally restrict this to discussions about adults. The less restrictive alternatives to guardianship we're going to talk about are advanced healthcare directives, surrogate decision making. Sorry, I don't know if I need to do anything about this. Okay. Less restrictive alternatives are advanced healthcare directives, surrogate decision making. Those are both issues involving making decisions for health, and powers of attorney, which deal with non-health issues. We'll talk about those, and supported decision making, which can cover a range of issues. The other thing we'll talk a little bit about is when guardianship is appropriate and the different kinds of guardianship that exist. So informed consent, again, the baseline here is that all adults and some minors have the right to informed consent in making decisions about their health care, unless there's a determination that they are incapable of making an informed decision. So what does that mean? Informed consent, being informed, means the healthcare provider has to explain the diagnosis, the proposed treatment, what we want to do, alternatives. So what are some of the things that you could do instead, or what happens if you don't do anything, and the material risks of any proposed treatments and no treatment. So you have a right to be able to, if you go to the doctor and there's a reason why they want to prescribe a medication to you, to know what the medication does, why they think you need it, and what happens if you don't take it, and what will happen to you if you're taking it that may be aside from, lowering your blood pressure. It's a very personal process where healthcare providers are communicating with their patients about fundamental values. And what that means is that there is no one right choice. There's no decision that this is the right thing to do and anything else is wrong. The considerations involved here are preserving individual autonomy, being able to make decisions for yourself, beneficence, so serving the patient's interests, doing what the patient wants, non-maleficence, which is where we get do no harm, and telling the truth about what the various risks involved and the possible treatments involved are. So the general rule is informed consent must be obtained directly from the adult before in providing the care. And the responsibility for that is with the healthcare provider that's actually working with the patient. So that can be the hospital that you're in or the doctor you're talking to. There is an exception that a healthcare provider, and we have citations down at the bottom here where relevant to the specific parts of Maryland law, So a healthcare provider may treat a patient who cannot make an informed decision without consent if the treatment is of an emergency nature and nobody else is available to give consent. What does an emergency mean? That there's a substantial risk of death or immediate and serious harm to the patient, and the life or health of the patient would be affected adversely by waiting to find somebody to consent to the treatment. So in a few cases, as I said, a minor may have the ability to provide some informed consent for themselves. A minor has the same capacity as an adult if, in the judgment of the attending physician, the life or health of the minor would be affected adversely by delaying treatment. So again, we have sort of an emergency rule here. If there's a life or death threat to someone's health and they're a minor and we don't have an adult on hand, we may need to ask the minor for consent. In addition, if the minor is married or is the parent of a child, the healthcare provider still has to determine if that minor is competent, but that in those cases, that minor can be responsible for providing informed, or can be able rather to provide informed consent for themselves or for their child. And this is similar to what we would see if we were looking for an emancipated minor, so to speak. So if there is someone who's under the age of 18, but they are married or they are the parent of another minor child, then we may look at that and say, this is someone who has the ability to make decisions as if they are an adult. What does competent mean? So as I said, when we're looking at either an adult or a minor in these limited circumstances, the physician has to determine if that patient is competent. So someone who is at least 18 years of age for an adult and who has not been determined to be incapable of making an informed decision. So again, we see here there's a default. The default is people have a right to make decisions for themselves. That is the underlying principle we're going to be coming back to over and over again today. And that's why guardianship is such a significant step to take. Who is someone who is incapable of making an informed decision? A patient is incapable if they are unable to understand the nature, extent, or probable consequences of the proposed treatment. So again, we talk about the proposed treatments and the possible alternatives and what happens if there's no treatment. To be able to make an informed decision about your healthcare, you have to be able to understand all of that. You have to be able to process it and think about what it is that will happen if you either do engage in the particular treatment or if you decide not opt out. If they are then unable to make a rational evaluation of the burdens, risks, and benefits of the treatment, or if they're unable to communicate a decision. We're going to talk about this later, but being unable to communicate does not just mean in terms of speech. There are other modalities that we have to consider, but if someone is just unable to communicate altogether, then they are incapable of making an informed decision or providing informed consent. So when we're looking at this capacity to make an informed decision, what is the decision we're looking at? There can be different types of decisions. There can be different levels of capacity. Does the individual have an understanding of the consequences of the decisions? What do people who know that individual say about decision-making capacity? And are the current decisions consistent with past stated wishes? And that's something that comes up, for example, a lot if we're talking about life-sustaining treatment or something that may affect someone's ability to communicate. I see a hand. I'm just going to say if everybody can wait to ask questions, I will try to have some time at the end and possibly if we have a natural breaking point as well. So many factors can affect someone's capacity: age, temporary or permanent mental impairment, addiction, physical, emotional trauma. As I said, there are many things to consider in terms of what the decision is. It can also be situational. So if you have someone who, for example, who has sundowners and, has a sundowner situation where their ability to process, to be cognizant, to understand and make decisions may be less capable after dark or as the day goes on or as they become more fatigued. Those are things that can affect someone's capacity, but may mean that we need to make sure we're thinking about when we're asking about their capacity. Is it in the morning? Is it when they're fresh? It's when they've had something to eat and their energy is up. This is a citation to the Maryland rules for attorneys, and this was changed just as it says here, about 2 years ago, to make it clearer. There are a lot of things we as attorneys need to do to make sure that when we are speaking to our clients, we think about their ability to make decisions for us, because the default again is, if I'm an attorney and I'm representing a client, unless I've specifically been appointed as a best interest attorney, I need to represent that client, what that client says they want, and not what I think they want. And so being able to do that means we have to think about when can we ask them to make decisions about what it is they want. What incapacity isn't is old age. Just being older, maybe being slower in thinking and talking about things is not incapacity. It doesn't mean someone can't make that decision. Eccentricity, being odd, being someone who is engaging in a life that may be outside the norm is not incapacity. Poverty is something that does come up a lot, particularly when we are dealing with clients in hospital settings, for example. If they are unable to afford a particular course of treatment, they may refuse that treatment. That doesn't mean that they're incapable of thinking about it. It means they're making a reasoned decision on their own. Again, refusal of care, like I said. People may have lots of reasons to decide they don't want to engage in a particular course of treatment, and disagreement with a recommendation, which can be a big issue for when we're dealing with healthcare providers. They may think that they know what's correct for the decision for the patient. And a lot of the time there can be a trigger to think about what is going on, or maybe to consider alternatives for decision making when the patient says they don't think they disagree with what the doctor is recommending. And this is broad. Applies to that, but it applies to lots of other things as well. People have a right to make bad decisions. And so sometimes when we are as attorneys are talking to people, either in guardianship situations or outside of that, they may think, well, my friend, my relative, my son, my daughter, my parents are doing things that I don't think are right. And I don't think that that's the right thing for them to do with their time, their money, their life. That is not necessarily an indication that someone can't make decisions for themselves. It may be, but it may also just be that someone is disagreeing with the doctor or the parents or the family right now. We also talked about communication, that being unable to communicate a decision is a mark of incapacity. A person who is otherwise competent but communicates through a method other than speech is not incapable of making an informed decision. So again, sign language obviously means that that's someone who can still communicate an informed decision. But if they need some sort of technology, if they need some sort of assistance, if they need some kind of augmentation that will allow them to communicate, that is not someone who is incapable of making an informed decision. So we've talked a lot about all of these factors that someone should be thinking about. A doctor, certainly, but also family members and friends and other people around the patient should be thinking about, in terms of thinking about if they are capable of making an informed decision, if they have that capacity. When in doubt, get a second opinion. So an older adult with dementia, and many of these are our clients, an older adult may have dementia, but they may still be able to articulate reasonable decisions in terms of what it is they want, in terms of what it is they don't want. And if we determine that they lack capacity, we're setting that all aside. So one of the things that you may need to think about is it someone whose dementia has completely impaired their ability to make those decisions, or is it someone who we should still be thinking about it and seeing if we can tailor the decisions and the communication to what they can still do? A younger adult with an autism spectrum disorder, again, like I said, if someone has a disability that may impair their communication or may affect how they communicate things, that is something that needs to be considered in terms of whether or not they lack capacity, because someone, again, who needs an augmented communication device or an assistive communication device, that doesn't mean they necessarily lack the capacity to communicate. And they may have a very strong feeling about what they would like to do, and it is not appropriate, I should say, I guess, to just set that aside because we don't have the specific communication device at hand. We need to be taking steps. Again, not an emergency, but if there is something that is not threatening life and limb, we need to be taking steps to try to make sure we're getting information from the person and also assessing the capacity and asking someone else to step in. And similarly, an individual with an intellectual disability may affect communication, may affect levels of cognition. It may change whether or not someone can understand what specific treatments mean, but they can still express what it is they want. And so, again, capacity should be the baseline. Informed decision-making should be the baseline before we move on to say, no, we're not going to let this person make a decision for themselves. When we do make that determination, pardon me for a second, particularly in the context of healthcare decision-making, if we've decided that this is an individual who lacks capacity to make an informed decision, informed consent can instead be obtained from a healthcare agent, a healthcare surrogate, or a guardian. And those are three different categories, and we'll talk about how those come into play. So an advanced healthcare directive is a written document that expresses a patient's healthcare wishes for the future. That's the advanced part of it. It allows the person signing it to choose a healthcare agent who can make decisions relating to when healthcare is provided or when it's withheld or withdrawn. It allows the person signing it to state preferences for specific healthcare or specific situations, including what happens if they have a terminal condition, what happens if they are in a persistent vegetative state, or an end-stage condition. I'm going to be talking about, when I talk about the advanced healthcare directives and surrogate decision-making, these are all part of the Maryland Healthcare Decision-Making Act. So this is all in, when it's down here, it says the Health General article, Title V, Section 6. So all of these are part of the same part of the law that talks about making decisions for healthcare. Now, I said an advance directive would be a written expression of the person's will. You can have an oral advance directive that is effective if it is made in the presence of an attending physician, a physician assistant, or nurse practitioner. So one healthcare provider and another witness, and then they record the patient's wishes in the medical records, and that is then signed and dated by the healthcare provider and the witness. Now, this is there. This means that if somebody ends up in the hospital and they haven't already executed an advance directive, they can create a healthcare agent for themselves while they are in the hospital or while they are receiving healthcare. But as a general policy, it would be more prudent to have a written advance directive ahead of time. Now, what we've talked about is how do you make it, right? How do you get this advanced healthcare directive in place? So you write it down, you nominate your healthcare agent, you say, this is the person I want to make decisions for me if I can't. You detail what it is you want that person to do, if there are specific things to avoid or specific things to do. But what does that mean? Right now, we just have a written document. Well, for that document to go into effect, for the agent to be able to make decisions for the patient, two physicians must certify in writing the patient is incapable of making an informed decision about treatment. So they have to go through the whole process we talked about of analyzing capacity to provide informed consent. They have to reach the decision, nope, this person can't do it. And then they have to make a certification in writing. And one of them, at least one, has to have examined the patient within the preceding 2 hours before the certificate is signed. They must be based on personal examination. And if the patient is unconscious or unable to communicate by any means, only one physician's certificate is required. But just to be clear, again, you have your signed advanced healthcare directive, you have nominated an agent, and it does not go into effect until and unless at least one and usually two physicians say, yes, this person can't make decisions. This patient, I should say, cannot make decisions. Once that agent is authorized to make decisions for the patient, They have powers that are tailored by the language of the healthcare directive. So it may give the agent the power to request and review medical records, authorize admission to a hospital, authorize discharge, decide what steps to take in sustaining the patient on life support. This would again be detailed within the advanced directive. It could be broad. The advanced directive could be broad and say, I give my agent full powers to make decisions for me. Or it may say they can't discharge me. They can't take me off of or put me on life support. But it would be detailed within the advanced healthcare directive. And that's why, again, to go back, these are all very personal, individualized decisions and are not just a one size fits all, one thing is right and everything else is wrong kind of a situation. There are limits outside of the directive on a healthcare agent's authority. They cannot require a physician or healthcare provider to prescribe or render medical treatment that the provider determines to be ethically inappropriate or medically ineffective. And that makes sense because these providers are going to be saying, if I'm not going to provide a certain level of care, if it's not going to have any effect on the patient's life or health. There's also an advanced mental health care directive, which allows the principal, as we call them, the patient, to decide ahead of time what mental health services they want and what they don't want if they become incapable of providing informed consent. They can include preferences of particular professionals, particular facilities, or particular medications the patient wants or does not want. Let me just see. Before I get to that, let me just say the mental health. Here we go. The mental health directive does not override Maryland law in terms of when healthcare providers can administer medication against the patient's voluntary will. So if a patient is saying, no, I'm not going to take it, the advanced mental health directive does not override that, and also does not override the sections of Maryland law that deal with when someone could be admitted for psychiatric care in a psychiatric care provider, a facility, against their will. So again, these don't override the will of the patient. But if there is someone who has been determined to be incapable of making an informed decision, the agent in the advanced mental health directive can look at that to say, oh, he hates this medication. He doesn't like it. It makes him break out in hives, or makes him gain weight, or she hates that hospital or doesn't want that doctor anywhere near her. So it does give guidelines for it. It does not override the free will. And neither of these do, really. These are designed to be assist in decision-making when someone is, as I said, incapable, incapacitated, not capable of making decisions or communicating their decisions. So when you have one of these, what do you need to do? You don't leave it in a drawer. So you don't just set it aside and you've done it, now you're done. You need to give hot copies to the agent. They certainly need to know what's in there. Healthcare providers and family members. Everybody should know what your wishes are for that. You don't have to go into all of the detail, but everybody should know who is responsible for making these decisions, particularly your doctors, your primary care physician. If there's a facility you're going to all the time, you want to make sure they have a copy of it because they know who to call then. Have an open and candid conversation with your agent about your wishes. This is particularly true in terms of life-sustaining treatment. If there are things you do want or don't want, your agent needs to know so they are not just guessing about what it is they think. And review your directives on a regular basis. So, for example, as we discussed, I was in the Peace Corps for a while right out of college. And while I was in the Peace Corps, I had a health directive and a power of attorney that named my parents as my agents to make decisions for me. But that's been a long time ago, and I don't necessarily want that. I've been married for almost 20 years. I'd rather have my wife making my decisions for me at this point. So if you have a directive, you want to be modifying it if your life changes. And also certainly if that agent is no longer in your life, there needs to be somebody else to make decisions for you. As I said, this is all part of the Maryland Healthcare Decisions Act, and we've talked about what happens if you have an advance directive. So if you've sat down, you've thought about it, you've had somebody write it out for you, you've signed it, it's in place. That's one way of someone making healthcare decisions for you if you can't provide informed consent. That same part of the law allows people to make healthcare decisions for family members or friends, even if the patient did not complete an advance healthcare directive ahead of time. So these are called healthcare surrogates, where we talk about surrogate decision making, and health surrogates are articulated in the law. There's a priority list. What order do we look for? Well, we look for if the patient has a guardian. The patient may have a guardian that is authorized to make some decisions, but not all. And so this may be a reason to look for them. The patient's spouse or domestic partner, an adult child of the patient, a parent, an adult sibling, or a friend or relative subject to certain requirements. So again, this is a priority list. If you find one, you don't keep going. If you have a spouse, that spouse should be the first person that the healthcare provider is looking to make health decisions for you. If you don't have a spouse and you don't have an adult child, then they should look for your parent, not looking for adult siblings. But the other part of this is it depends on when the decision is needed, and it depends on who's there at the time the decision is needed. So sometimes your spouse may be overseas and your adult child may be there, or your parent may be there. Well, then they're going to have to look to your parent for the decisions if the spouse is not available. So availability plays a role here as well. It's not just does this person exist? It's are they available and able to make healthcare decisions for the patient. A friend. So as I said, the last part of that priority list is a friend or a relative. It's not your spouse, it's not your kids, it's not your parent, it's not your brother or sister. When do we look to these people? Well, if they are a competent individual, again, they have to be over 18, they have to be able to make informed decisions, and they can present an affidavit to the attending physician stating they are a relative or close friend of the patient. So it would say you would want to have in there detail like, I've known Bob for 15 years. We used to work together and now we see each other once a month. And specific facts and circumstances demonstrating the person has maintained regular contact sufficient to be familiar with the patient's activities, health, and personal beliefs. And this goes back to, again, we don't want somebody deciding what's in the patient's best interest. We want someone as a surrogate making a decision that the patient would make for themselves if they were able to. If someone doesn't want that life-sustaining treatment, if someone doesn't want to be maintained on life support for a certain period, beyond a certain period of time, the surrogate would be the person that the hospital would be looking to, or the healthcare provider would be looking to make these decisions, and we want them to have a reason to know it. So again, it may be a question of talking about it. You have that, we have had this discussion at Thanksgiving dinner last year, for example, or we had a long heart-to-heart discussion about after our grandmother was in the hospital. Whatever it is, whatever the details are, it should be in this affidavit that is signed by the surrogate, who's a friend or family member, extended family member, that tells the hospital, that tells the doctor, whatever the healthcare provider is, why they should be looking to this person to make decisions. Again, like with the advance directive, before a health surrogate can be appointed, 2 physician certificates have to certify that the patient lacks capacity. And as I said, a surrogate has to make decisions that, in their experience, best represent the patient's wishes, not the surrogate's decision of best interest. That may include knowledge of the patient's religious or moral beliefs and express preferences for withholding or providing treatment. The decision of a surrogate regarding life-sustaining treatment shall not be based on the patient's pre-existing long-term mental or physical disability or a patient's economic disadvantage. We can let the patient make those decisions, but the surrogate can't just decide, well, they're too poor to be able to receive this treatment. Or she has had a mental illness for 10 years, so we're not going to maintain her on life support. And again, this is just regarding life-sustaining procedures. A surrogate cannot authorize sterilization. And again, treatment for a mental disorder can't be provided by any kind of healthcare surrogate. A healthcare provider may not withhold or withdraw life-sustaining procedures on the basis of an advance directive where no agent has been appointed, or on the basis of the authorization of a surrogate. So if there's an advanced healthcare directive that details what sort of procedures the patient wants, but there's no agent named, the healthcare provider cannot withhold or withdraw life-sustaining treatment on that basis. Or again, if there's just a surrogate, the healthcare provider cannot withhold or withdraw life-sustaining procedures. They could provide them, however. And again, without special certifications, so that requires, the law goes into what it is the healthcare provider would have to do to be able to look to the surrogate for these decisions. A healthcare provider can withhold or withdraw life-sustaining procedures only if the patient's attending physician and a second physician have certified the patient is in a terminal condition or has an end-stage condition, or two physicians. So again, these are just physicians' decisions. We don't have the other healthcare providers involved here. Either two physicians are certifying there's a terminal or end-stage condition, or a physician and a neurologist, neurosurgeon, or other physician with expertise in evaluating cognitive functioning certify the patient is in a persistent vegetative state. So we have to have additional certificates attached in those cases. All right, I see some questions. I see some stuff in the chat here. Let me just take a quick look.
Thank you, Jim. You want me to read some of those questions?
Yes, please. That would be great.
Oh, I'd be delighted. Okay. Where do we get the forms for advanced health directives?
So there is no one approved form for an advanced healthcare directive in Maryland. We'll talk about powers of attorney in a little bit, but there is an approved power of attorney form. There is no one approved advanced healthcare directive form. I believe the Maryland Attorney General's office does maintain a general advanced directive form on their site, and that's great and that's usable, but it's not the one official form. So it is certainly available from, I would guess most lawyers can provide one. You can certainly, as I said, find one on the from the Office of the Maryland Attorney General. And in fact, I think my experience has been that most healthcare providers, if you ask for it, may also have one on file tailored to the needs or preferences of that particular provider, whether it's, the system or the office or whatever.
Thank you. And then one other question here. Where do we get a second opinion about capacity? From a personal physician, or?
It would be, well, so there are two parts to that, I guess. One part is that should be prior to any surrogate getting involved. That should be something that a doctor or other person looking for decision should be doing. So if I'm doing that, if I'm dealing with a client and I'm concerned my client lacks capacity, I want to ask another attorney, or I may contact their doctor, or I may ask their family members. I don't want to disclose confidential or privileged attorney-client communications, but I can certainly say, has client ever expressed to you what they want in these circumstances, and then I can get some information to think about what I'm dealing with, and if I have a concern about it. Doctors should be doing the same thing, and if family members are in a position where they think, hey, I think you're overriding my son's or my mom's or my brother's decision making too quickly, you can certainly say, I'd like to get another physician to weigh in on this.
Okay, and that's it for the questions so far.
Okay.
Oh, sorry, one more. Do you need to have the directive in place before the child turns 18?
So as I said, the presumption in Maryland law is that anybody, so a minor, someone who's under 18, is the natural guardian of that person is their parents. And so there is not really, they don't have capacity in the legal sense to be able to sign an advance directive before they turn 18. You could certainly have it it's certainly something that could happen on their 18th birthday.
Okay, thank you. Okay, and let's go on and then
Okay.
as you guys have extra questions, please put them in the chat and then
Yeah.
Jim can address them towards the end of the session.
Yeah.
Thanks.
And like I said, if there's another breaking point, I will find
Perfect.
it as well.
Perfect.
So I just want to briefly talk about supported decision making. This is fairly new. In 2022, the Maryland General Assembly passed the Supported Decision Making Act, which is another less restrictive alternative to guardianship. The purpose of supported decision making is to assist adults by obtaining support for the adult in making, communicating, or effectuating decisions that correspond to the will and choices of the adult, and preventing the need for appointment of a substitute decision maker, including a guardian of personal property. Supported decision making allows a person to retain some authority without appointing a substitute. So it doesn't override their ability to provide their input, and just means that there are other people weighing in to give them advice and give them ideas. This is a process many adults with and without disabilities already use. Adults look to friends, family, neighbors, trusted professionals. If they have a lawyer, and they may call their lawyer to give them information about life decisions. For example, what kind of car to buy, or whether to undergo a medical procedure. So these are decisions that not everybody has the expertise to make on their own. And in addition to, getting advice from getting a recommendation from their doctor, they may talk to their parents. They may talk to their husband, their wife, or just friends to see, hey, what happened when you dealt with this? What did you do? What were you thinking about? Or, what did you see when your mom had this kind of treatment? The adult asks for advice, weighs the information he receives, and makes a decision. Supported decision making recognizes that this goes on as a less restrictive alternative to guardianship. Now, the act set out and reflected in Maryland law identifies a process by which an individual with a disability or without a disability can formally identify supporters that she trusts in making life decisions. An adult can authorize supporters to get information from official sources, so call the doctor's office, call the lawyer's office, to get information, help the adult understand that information, and make a decision based on supporters' input and the adult's wishes. I'm not going into deep detail on some of this because, first of all, this is very new. As I said, it was passed in 2022. It went into effect in, I believe, October of 2022. And it hasn't been deeply tested in some ways yet. It's not entirely clear how it works in all areas. What I can say that I didn't go into complete detail on the slides here about is that there are requirements of the supporters about what they have to do. So, I mean, the main point here is the supporter, again, like we talked about with surrogate decision making, is not supposed to be substituting their judgment on what is in the adult's interest, what is in their best interest. They are supposed to be helping this adult make a decision. And that means by saying, well, you like X, Y, and Z. You want to be able to have the free time to go, to go on a vacation, right? Well, if you are spending your money on this new car, you won't be able to afford the vacation. Or, you've said you want to be able to go to your sister's wedding. And I'm concerned that if you don't get this medical treatment, you won't live to see your sister's wedding. Obviously, that's an extreme example, but that's the idea, is not to say you have to do it, but to help them think about what it is that's important to them and contextualize the decision that they're making. The other aspect of it I should point out, and again, I didn't go into detail in the slides about this, is that a supported decision-making agreement can exist when someone is under guardianship. So if there is a guardian appointed by the court, the disabled person, the ward, the subject of that guardianship, could still enter into a supported decision-making agreement to be able to make some decisions on their own still. That could be where they want to live. They may be able to agree to enter into a particular residential placement or a particular group home placement, or be able to identify how they want to live independently. And the supported decision-making agreement can help effectuate that. It still means it doesn't replace the guardian, but it may be an indication that a guardianship is not as necessary as it seemed at some point. So that's, as I said, that's supported decision making. It can cover, and again, the other part of it, like I said, in terms of advanced directives, and as we'll talk about with powers of attorney, is it can be as broad or as narrow as the agreement wants to be. As the person wants it to be, they can say, I want help with just making decisions about healthcare. I can do everything else on my own. Or they may say, I only want to, or I have a guardian to make decisions about my healthcare. I only want help making decisions about my life choices in terms of being able to live out independently in the community. Or again, it could be very broad. It could say, I just want these people to help me with everything. Or I want this supporter to help with that and this supporter to help with that. So it's can be tailored and should be tailored very individually to the needs of the individual, the adult signing that supported decision-making agreement. So a power of attorney, we've talked about healthcare decision-making through advanced healthcare directives, through surrogate decision-making, and maybe through a supported decision-making. Power of attorney does not deal with health decisions. A power of attorney allows an individual to choose a person they trust to manage property and financial affairs. And that, again, is going to be their agent. It can also, under Maryland, there's a form for it in Maryland law, and that form allows the person, again, we're going to call this person the principal, what the law calls them. The principal is the person making the power of attorney. The principal is the person designating an agent, and can also allow the principal to designate who they want to be appointed as guardian if that is determined to be necessary at a later date. So an agent has authority to act for business and property matters that are specified, such as accessing bank accounts, taking out loans, buying real estate, and entering into contracts. That could also mean, for example, a contract to retain an attorney to engage in a lawsuit on behalf of the principal. But a power of attorney only grants the powers to the agent that are defined in the document. When do you appoint a guardian of person? Sorry, this is getting to guardianship. I thought I had a couple more on power of attorney here, so let me just talk about it a little bit more. There are, in this case, specific forms that is a statutory form for a power of attorney in Maryland law. That form is obligatory, which means that once upon a time, before we had this, which I believe it went into effect in 2010, I think this is when they made the change to Maryland law. Prior to 2010, you could just make a power of attorney. And as long as it was signed by the principal and witnessed by two witnesses and notarized, that power of attorney was effective. It could be 1 page, it could be 50 pages, but it was sort of a free-for-all in terms of that. And what that meant was that you could think you have a valid power of attorney in place, but then you go down to M&T Bank or you go down to PNC Bank and you try to use your power of attorney to help your mom or your sister or your son or your neighbor. And the bank says, oh, we don't take that one. We have our form. And you would have to get then the person to sign that form as well. Well, when the statutory form went into place, as I said, it's obligatory, which means that you can't now, if you take that obligatory statutory form to PNC Bank or M&T Bank, they can't say we don't take this. If they say that to you, you can retain an attorney. The attorney that can then write to the counsel for the bank or take them to court and ask for an injunction, and you can recover attorney's fees for having to go through that process. So it is something that is a specific form. It is in the Estates and Trusts section of Maryland law, and it is designed to be not one size fits all, but one form is usable for everybody. There is a general power of attorney, which is very broad. It covers everything. As I said, there's bank accounts, there's loans, real estate, contracts. All of those are included, and other powers are included in the general durable power of attorney form. There is also a limited power of attorney form, which allows the principal to go through and say, I only want, and it's not inclusive, it is exclusive. So I think I'm saying that the right way. In other words, the principal is going through the limited form and only designating the powers they want someone to have. So you initial it when you're filling it out. And if you say, I want someone to be able to access my bank accounts, I want someone to be able to get my mail, but I don't want them to be able to enter into a contract, you can do that. You can limit it to just those powers. The other aspect of this, and as I said, with an advanced healthcare directive, that the patient has that, and it's great because it says who the agent is, but it doesn't go into effect right away. It still needs these 2 certificates from physicians to really go into effect. A durable power of attorney, rather a general power of attorney, is in effect right away. As soon as you sign it, the agent can go out and start using it. So when we talk to clients about this, we make sure we say to them, this needs to be somebody you trust. You shouldn't just sign this for everybody. And you shouldn't sign it for multiple people unless you really specifically want multiple people to be able to do this. So maybe someone is signing it for their mom and their dad to be able to do it because they know their mom and their dad will work together. But you don't want to have the neighbor on that side and your second cousin and your grandparents' neighbor on the other side to have the power of attorney for you, because those are all going to be able to go out and do things on their own. And then it creates a level of chaos you really don't want with your business and your property affairs. So as I said, these are all the issues with the power of attorney. And when we say durable power of attorney, what that means is it is durable in that it endures if a person has been determined to lack capacity at some point after they sign the power of attorney form. So you sign it, a year later, you get in a terrible car accident, you're in the hospital. It doesn't matter that you have lost capacity now because the power of attorney is a durable power of attorney, and that means it endures. You can make a power of attorney non-durable, but that is in the Maryland statutory form, that is not what is favored. It is a durable power unless you make it something else. I'm going to go into guardianship now, so I guess I can stop for a second and see if there are any other questions before I move on to that.
Yes, let me see. I think there were some about power of attorney in particular. Do you need a power of attorney if you establish a special needs trust and have no income or properties in their name?
If there's a special needs trust, so that's a trust that benefits the person with a disability, the money that is in the trust's name or that is in the trust is not it's not an asset of the individual. It is for their benefit, but it's not theirs. They couldn't walk into a bank and just withdraw it right away. I don't know all the circumstances for everybody, so I can't say for sure whether or not you would need a power of attorney. It depends on what else is going on in this person's life. So if it is someone who's in a hospital and they're not going to be leaving the hospital, but there's a special needs trust to care for them, or if they're at home, but they're going to be constantly under heavy, 24/7 care, you might not need a power of attorney. But if it's somebody who has a special needs trust or an ABLE account, but they also are going out and working a job and they have a bank account where they get, their money deposited from their part-time job, maybe you want to have a power of attorney in that case to be able to deal with that if the person becomes incapacitated. So that is a question that would be an individual case-by-case basis. There can be some situations where it would be. There may be certainly situations where the special needs trust covers everything.
Thank you. And then we have a couple questions on supported decision-making. I'm just going to kind of combine them. What documentation would be necessary to prove capacity, or what if somebody like a doctor says young adult they feel that young adult does not have the capacity. So what's needed to go through that process?
Well, capacity is not specifically a part of the supported decision-making question. as I said, you can have a supported decision-making agreement in place for someone who is also under guardianship. And if you're under guardianship, by definition, a court has determined that you lacked capacity, at least at the time the guardianship was put in place. So it is not specifically a question of capacity. It's really a question of being able to articulate the needs or the issues that are set out in the supported decision-making agreement. So it could be, as I said, it could be as limited and as simple as just who's going to help you figure out, where you're going to be living when you make this decision before you have your DDA placement get put in place. Or it can be very detailed. It could be about getting a car. It could be about, how to spend your money. And if you have a special needs trust and you only have, the money from your part-time job, you still may want someone to be able to help you make decisions about that, without just taking the account away from you. So it's not a capacity question so much as it's a question of, can you go through the steps necessary to enter into it?
Thank you, Jim. Why don't you continue here? I know we're getting to about the 1 o'clock time. I know Jim said he will hang on and try to answer some more questions. You have a little bit more material to cover, yes?
I do. I'll
Okay.
very quickly go through guardianship. We've been talking about this as alternatives. So what I will do now is just quickly cover guardianship. So you appoint a guardian of the person. There's two types of guardianship: guardian of person and guardian of property. Guardian of person is necessary if a person lacks sufficient understanding or capacity to make or communicate responsible decisions concerning his person due to any mental disability or disease. And there have to be no less restrictive alternatives of ensuring that person's health and safety. We've talked about what those are. That's power of attorney, advanced healthcare directive, possibly supported decision-making agreement. So if those are there and they haven't worked, or if the person is not capable of entering into them, then a guardian of person may be necessary at that point. Guardian of property, on the other hand, is necessary if a person is unable to manage his property and affairs effectively due to any mental disability or disease, and the person has or may be entitled to property or benefits which require proper management. So a guardian of property, even if someone can't make these decisions, may not be necessary at all if all of the money is held in a special needs trust, or if they don't have any money and they are just going to be funded somewhere by medical assistance. There may not be a need for a guardian of property. If they do have either benefits or property that require management, then there may be a need for a guardian of property. What happens is an interested person can file a request, petition with the court asking to be appointed as guardian of person and property, or guardian of person or guardian of property of an individual with a disability. Interested persons means a guardian, the heirs of the disabled person, any agency paying benefits, or any person or agency eligible to serve as guardian of the disabled person. So what that means is there are guardians of last resort, what we call public guardians. DSS, Department of Social Services, is the public guardian for anyone 18 to 65. And 66, or rather 65 and over 65, rather, the local area agency on aging is the public guardian for those people. And so what that means, again, is that when there's a petition, they have to receive notice of the petition and the fact that this person may need to have a guardian. The petition must be accompanied by 2 certificates from healthcare professionals stating that this person requires a guardian. Those healthcare professionals are either 2 physicians or 1 physician and 1 psychologist, nurse practitioner, or licensed certified clinical social worker. So those are the categories we can get. As I said, one of them has to be from a physician. The Maryland court system has developed forms for these that are different forms for each one, but those are the ones that have to be used to accompany guardianship petitions. At least one of the professionals must have evaluated the alleged disabled person within 21 days before the filing of the petition. I talked about this a little bit earlier. Alleged disabled person is the person who's the subject of the guardianship. They are alleged because they have not yet been determined to need a guardian, and so they are alleged to have a disability, but we have not determined that they have a disability that incapacitates them to that level. So they are alleged disabled persons is the kind of clunky legal term. Sometimes we use ADP, which I think is frankly a little clunkier and more dehumanizing. And sometimes we just talk about our clients. After receiving the petition, the court will appoint an attorney to represent the interests of the adult with a disability. That's me and the attorneys that work with me. We are the supervising, as I said, I'm the supervising attorney for the adult guardianship program. We represent clients who are the subject of these guardianship petitions. And that means we go out and we meet with them when we get appointed, and we talk to them about what it is they want. Do they want to have someone appointed as their guardian? If they have a family member, do they want a family member doing that? If they don't, do they want a public guardian? We have to represent their interests as well. So we are not best interest attorneys. We are representing them and telling the court, this is what my client said. Hearing on guardianship may be held as a jury trial. The attorney for the alleged disabled person can waive that right to a jury trial. These hearings are closed and confidential unless a court decides to hold an open hearing for good cause. I have not seen that in my experience since the decision has been made to have these as closed and confidential hearings, and all of the records are sealed, the dockets are sealed. So that means you can't just go in and look at somebody's guardianship information, because there's a lot of sensitive information about the alleged disabled person, about their family members, about their money. So those are all sealed. There would have to be a reason why they were unsealed, and I think courts would generally be very reluctant to do that. As I said, there's a right to a jury trial. So either a judge or a jury will review the petition, the certificates, the court-appointed attorney's answer, and any other evidence. If there's an actual trial, you're going to have witnesses probably coming in to testify about it. And then the judge or the jury will decide whether the person with a disability needs a guardian, and who should it be? Are there family members? Are there multiple family members? If so, who's better situated? Or do we have to go to the guardian of last resort, the public guardian? Revised rules governing guardianships went into effect in 2018 that set out training requirements for people appointed to act as guardians. There's both an orientation program that's about 10 minutes. It's online, it's a video. And there is a training program that is, again, online, that lasts about an hour for guardian of person and property, that are required viewing for people appointed. There used to be in-person trainings. I know in some courts, I believe those have not been in place since COVID. An adjudication of disability for purposes of appointing a guardian may not be the basis for commitment of the disabled person to a mental institution. So as I said, you can't shortcut the Maryland rules and laws for involuntary admission to a psychiatric facility, or Maryland laws regarding involuntary administration of psychiatric meds. You've got to go through the same process for those all the time, no matter what, whether there's a person has a guardian, whether they have a surrogate decision maker, whatever, the same rules apply no matter what. Appointment is also not evidence of incompetency, and does not modify a civil right of the disabled person unless the court orders, including any civil service ranking, appointment, and rights relating, unless the court orders so, rather, I should say. So the court order will have to specify if there's a change to the person's right to appointments, privileges, benefits, etc. That includes the right to vote. So this is my disclaimer that just says, if having heard this, if you have questions, I can talk to you about a little bit about it now, but this is not the complete and total answer. And if you have specific questions, for example, the question about the power of attorney with a special needs trust in place, you probably need to speak to an individual attorney about your particular case. So that's the end of that, and I can take other questions if there are any questions.
We have a lot of questions. Let's go through a couple, and then
I'm going to stop sharing here too. Sorry.
Yeah, thank you, Jim. Excellent overview of all these questions, and good discussion. So let me go back up here. Some of these apply more to more traditional guardianship, so I'm just trying to go through ones that there were some additional questions about supported decision-making, about where someone could find more information or forms or that kind of thing for next steps. For supported decision-making.
What is the question about it? I apologize.
Is it a legal document? Are there forms? Where can somebody find, those forms and next steps?
So there are forms. There is not a specific, again, there's not a statutory form like with the power of attorney. So there's not like one form for the entire state of Maryland that everybody knows and accepts and deals with it. But there are forms that are available online. It's an increasingly used alternative to guardianship or whatever the similar guardianship situation would be in other states. And so there are forms, if you just Google supported decision-making agreement, you will find some things online. Particularly Disability Rights Maryland, DRM, does have some materials, and I believe they have a sample agreement. And they also have supporter agreements for the supporters to say, yes, I agree to do this. I agree to support this person in this way. So you can find that, as I said, if you just Google supported decision-making agreement, you will see some available alternatives online for you.
Thank you. Let's see.
And frankly, I will also say supported decision making, as it's very new, and it is something that I think probably merits its own entire presentation. I didn't have a time to do all of that today, but it is something that's also growing, and everybody's learning about it and figuring out how it works.
Absolutely, that's good. And how long? No, I think we answered that one. Sorry about that. Do you need power of attorney if you establish a special needs trust? Did I do that one already? And they
Yes.
have no income. Okay. And what's the difference between a general and a durable power of attorney?
A durable power of attorney, as I said, that means that's something that lasts even if the principal loses capacity later. A general means it's broad. So you can have a general durable power of attorney or a limited durable power of attorney. They are two descriptions that can apply either to different documents or the same document.
A lot of questions in here about power of attorney. With each of these types of guardianship, there needs to be someone with the representation ability. What if you don't have anyone in the family or friends who can do this?
So that's what
This is from a self-advocate. All the people we trust are my age. So we need to look for someone who is there for her lifetime.
well, I guess I'm not clear on the circumstances from that. If it is, if there is someone who doesn't have family members available, but they have people that they trust, that they like, that are reputable people, they could ask for that person to be appointed as their guardian of person or property. The court may accept that decision, but the other part, I didn't go into this detail, but there is a part of Maryland law that says a guardian of person and property should not be someone with a felony conviction unless there is good cause, and good cause might mean there's nobody else to do it, but it's certainly going to be a reason that would give the court pause to appoint someone as guardian. So it's possible to have non-family members doing it, but the court is going to want to know a lot more about them, particularly if it's not someone who's a close family member. And they may also require, even if it's a family member, they may require someone to post bond if they are being appointed as guardian of property.
Thank you. And I just put in the chat the website for Maryland Legal Aid. I will also share here momentarily Jim's email, if that's okay, Jim.
Sure.
And
I may not be able to answer all the questions, but
right. But I know
that,
what these situations show us that there are some very specific situations. I'm looking for your email.
Oh, my email, I can put it in here.
Yeah, if you would, that'd be great. And that's if anybody wants to reach out to you personally. And then I think probably we will wrap it up. And then again, we did record today's session, and this will be shared with everybody who registered along with the slides in just a few days. We have a version that's been recorded in English as well as in Spanish. So those will be on the Pathfinders and Autism Society websites and then emailed to everybody. So Jim, I want to thank you so much for a terrific discussion today and for sharing your knowledge with everybody. It's clearly very a topic of great interest for families, and so thank you so much for for spending this time with us this afternoon.
Thank you for having me, and I'm happy
Um,
everybody was here, and thanks very much.
All right. Take care. Thank you.